We'll get the meeting going. She made me do that.
That's what I want to.
All right, we're going to get the meeting going. I know, just let everybody know that the meeting is recorded. It's live, so just want everybody to be aware of that. Also, if you want to silence your phones, that would be great. With that, I'm going to call it to order and do a roll call. Looks like we have a quorum, which is great. I'm Shane Doherty, presiding officer with the Dallas Central Appraisal District.
And Tim Radloff, Lubbock Central Appraisal District.
Mike McDougall, private citizen from Lubbock.
I'm Sid Novella. I'm the chief appraiser and tax assessor collector with the Jim Wells County Appraisal District.
And Lee Rosenberg, a public member from San Antonio.
Great, so we're here, we got a quorum. At this point, I guess we're on to number C, training for committee members. I think we're going to probably pass that over to TDLR, let them go through that process, bring us some of us up to speed.
Yes. Good morning. My name is Elizabeth Salinas Strittmatter. I am an assistant general counsel, and I'm actually filling in for the deputy general counsel who is over this program, Della Lundquist, who is on an awesome adventure in Arizona and Colorado, as you see. So when she asked me to fill in, she said that you all needed to be up to date on the various trainings that we provide for our boards on open meetings and the Public Information Act. So that's what we're going to talk about this morning. All right, so we have three topics: Open Meetings Act, the Administrative Procedures Act, and the Public Information Act. The Open Meetings Act we're going to cover first, and I believe you guys probably have some materials there. Feel free to look on that screen, this screen. They both contain the same material, whichever's easier for you to look at. So as you know, the primary purpose of the Open Meetings Act is to ensure that we have a transparent government so that the public is always aware of the activities of our various agencies and our various boards. That is something that is of utmost importance, obviously, to us as government employees, and we want to ensure that you are following the various guidelines that are set out in the Act so you're not inadvertently violating the Act during conversations or during particular meetings. So there are three main requirements that we're going to talk about this morning under the Open Meetings Act. And the first is the notice requirement, which I think probably all of you are pretty well versed in. And this requires the government agency, TDLR in this case, to provide notice of the date, hour, place, and the subject of every meeting that's held. Notice must be posted at least 7 days in advance. We, as an agency, must provide notice of each meeting to the Secretary of State, who in turn posts it on their own website. And we must also, TDLR, must also post notice of public meetings on its website so that any member of the public or any interested party, as we see here today, can come and watch and see what our deliberations are about. Quorum requirements are extremely important. As you all may know, if you don't have a quorum, you cannot conduct official business. You may be able to discuss business matters, but you can't actually act on anything. So what we're looking at here is, just to give you guys an example, if you have a 7-member committee, a quorum is 4. If you have a 5-member committee, a quorum is 3. And like I said, if you do not have a quorum, if you just fall a little bit short, or you're waiting for somebody, things happen, maybe somebody is late for a meeting, you could technically start the meeting, but you couldn't actually do anything in terms of official business. So anytime you are short of a quorum, probably the best course of business is to try to wait to see if you can actually gather the quorum rather than start the quorum, begin discussions, and really not be able to do anything. The only things that you as a board can take up are matters that are under your specific authority and control as committee members, right? And you can only take formal actions on those matters. So what happens, we get a lot of questions about social functions. You guys probably attend a lot of conventions and a lot of meetings and a lot of yearly educational requirements that you need for your licensure. And you attend a lot of social functions, cocktail parties, or things that are related to those trainings. If you are at a social function and the social function is not related in any way, shape, or form to your public business that is conducted by your particular committee. You are only subject to the Open Records Act if you engage in a verbal exchange about official business over which you have supervision and control. You are not engaging in a formal meeting if there is conversation amongst you that is incidental to the social gathering. So, if you're at a convention, if you're at some kind of yearly educational meeting, and a quorum is present, you are not engaging in a meeting as long as your conversation about public business or public policy is incidental to the event and no official action is actually taken. So please be aware of any conversations that you have that occur outside of an officially noticed meeting where a quorum is present. Try not to, or not try, but don't engage in substantive conversations relating to matters over which you have control as a committee, as committee members, when a quorum is present and you're outside of an officially noticed meeting. And always be aware of the walking quorum. The walking quorum tends to be the situation that trips a lot of people up. A walking quorum is when you have less than a quorum of your committee members, but you are discussing official business over which you have control. And these walking quorums can occur in any form of communication, in person, over the phone, in hallways, anytime there's a communication. So what happens in these walking quorums is while there is less than a quorum of members who are engaging in that particular conversation, you may have another member who goes back and communicates those communications to another committee member or board member, and you may inadvertently be creating a quorum outside of an officially noticed meeting. So the example that we have here is on a 5-member advisory board, 2 board members exchange phone calls and emails expressing thoughts on an upcoming rules change and exchanging research that they have each individually performed regarding the issue. That in and of itself would be okay. However, one of the board members then forwards the exchange to another board member. We're a 5-board member committee that we're talking about here. This person has created a quorum. They've engaged in a walking quorum by having a small group discussion outside of an officially noticed meeting. And as you can see, some of the more familiar ways that walking quorums happen could be, as I said, in conference calls, video conferences, random hallway discussions, email, texts, and also beware of things like Twitter and Facebook and social media. You can also have quorums inadvertently created when you are having conversations about official business on those things. This frequently trips people up, so we just want to make sure that everybody understands that even on social media you have to be aware that you're not inadvertently creating a walking quorum. So to avoid even the appearance of impropriety, what are some things that you can do as committee members, or what you should not do? You should not meet in small groups and communicate those discussions then to other members of your committee. Send emails or text messages to a quorum of members regarding official business. And this is true even if you're individually sending emails. You're not sending a group email, you're sending the emails to individuals. As when you are sending those emails, you are still communicating to more than whatever the quorum is for your particular committee. You may be inadvertently creating a walking quorum. So, also be aware of polling. And polling occurs when you have a conversation with person B and you all discuss official business, and then you go back, and this is outside of a public meeting, and then you go back and you start asking for feedback from other members. This is polling, which is essentially conducting an informal vote on an issue. So just be aware of that as well. So guidelines for our open sessions are a board or committee is limited to discussing, as you know, the specific items that are on the agenda. Members of the public, of course, can come up and speak, and you can limit the time that they are allowed to speak, but there cannot be any open discussions about anything that's not on the agenda. So if a member of the public comes up and wants to talk about some particular property tax issue and that is not on the agenda for that particular meeting, you can listen to what the public
person has to say, but there can't actually be any discussion about it. But if you wish to discuss it later, you can put it on the agenda for a following board meeting, and then you can discuss it at that time. Okay, so to avoid violating the Open Meetings Act on the basis of insufficient notice, here are the things that we would like to see. We would like to see specific identification for agendas and communicating those, for agenda items, and communicating those items to TDLR, which, as you know, we have a wonderful staff that makes sure they circle to all of you guys and sort of check out if are there any items that you are interested in putting on the agenda that you'd like to talk to the agency about, to see if that is something that can be put on there. So feel free to access those folks. They're always available to you. Limit your discussions, as I said just a few minutes ago, to the things that are on the actual agendas. Try to, and this is a hard one for some subject matters, try to avoid having public commenters sort of just take control of the conversation and wander off and sort of start talking about things that are really not within your official business or that are not properly noticed. And you are well within your rights, as I said earlier, to have time limits on the public and to try to corral those comments to the extent that you feel they need to be corralled. And also don't respond or discuss issues, as I said earlier, that are raised in public comment but which are just not on the agenda. So what happens if we have a violation of the Open Meetings Act? Well, any member of the public can take a petition to stop whatever action you've taken during the course of the meeting. And a violation of the Open Meetings Act can also be voidable. That means if you take an official vote and a complaint is made and somebody seeks to stop that action and a determination is made that it is a violation of the Open Meetings Act, it's voidable and it's as if that act never happened. There can also be criminal penalties for knowingly violating the Open Meetings Act, and it can include county jail or a fine from $100 to $500 or perhaps both. So I think we have covered that. If you have any questions specifically about this, you can contact me or you can contact Deputy General Counsel Della Lindquist. Our email addresses are there, and we're more than happy to talk to you about the Open Meetings Act. So now let's move on to the Administrative Procedures Act. The Administrative Procedures Act, as you know, establishes minimum standards of uniform practice for our agencies and procedures for our agencies, and they allow the public to participate in a rulemaking process that sort of dictates the way, in our particular case, licensees can operate or can perform. And all a rule is a statement made by an agency that implements, interprets, or prescribes a law or policy or describes a procedure or practice requirement of a state agency. A rule must always include any repeal of past amendments, and a rule does not solely relate to the internal management or organization of a state agency. Any interested person can petition for a rule, and this is called initiating the rulemaking process. Any interested person is defined as a Texas resident, which is very broad, obviously, a business entity located in Texas, a state governmental subdivision, like an advisory board or a committee, and a public or private organization that is not a state agency, but that is located in Texas. And this is an example of where our rulemaking process kind of takes us. You start here with the idea for the rule. The rules are drafted and sent to the board. Proposed rules are filed with the Texas Register. Then the public gets to get involved, and they have 30 days to comment on those proposed rules. Then the General Counsel's Office gets involved and comments and recommends rule changes or provides legal advice. Then the board reviews comments, and then you recommend to the commission. The commission then has their own discussion about whether to adopt the rules. If they decide to adopt the rules, it's filed with the Texas Register, and the rule then becomes effective 20 days after the filing. The rules review process is also something that a lot of people have questions about. Some programs are on a 4-year rule review process. So every 4 years, you're going to look at your rules, You're going to provide notice of the intent to review the rules. Again, the public has 30 days to respond. The GC reviews and makes comments. Then the commission reviews the rules and the filings and readopts the rules if they find that appropriate. And then the board itself will be presented with any comments, and you can recommend any changes. All right, so these are your resources for where you can look for rulemaking. But again, a lot of this is very legal. So if you have a question or concern, feel free to contact any of us in the General Counsel's office. So the final act that we're going to talk about now is the Public Information Act. And as you know, the Public Information Act is the act in Texas that just creates, as we talked about at the beginning, all of the transparency for our public citizens so that they know what's going on within the agencies. Okay, so this is a very important act because it makes all documents, records, and other information relating to official business open to the public, but there are some exceptions. And this includes any electronic communication, which does include texts, created, transmitted, received, or maintained on any device. It does not have to be a state-issued device if it is in connection with official business. So if you, as a member of a committee, receive what you think is a public information request, forward it on immediately to the General Counsel's office. We are required to promptly respond to that request, usually within 10 days, and we cannot, including you or agency staff, cannot ask why anybody wants that information. It is what it is. We just have to say, okay, you're asking for the information. Let's see whether any exceptions apply. Let's send it over to the GC's office, and if no exceptions apply, then we will provide the information to you. So exemptions to disclosure, dates of birth, email addresses, social security numbers, which isn't on here, certain education documents, and of course any HIPAA, medically protected information. But things like addresses are generally public. Things like phone numbers are generally public. But that's why we want you guys, if you get something that you think might look like an open records request, send it over to us so we can gather those records and review them to see if there's anything that needs to be redacted before we produce it. Also, I don't know if you're aware, but there are instances where we receive a request for information and we may want to request a ruling from the Attorney General's office because we may think that it falls under some exemption that allows us to withhold it. So it's super important that these requests go through that analysis so we can make sure that we are protecting our internal information to the extent that it needs to be protected and timely releasing the information that's otherwise public. So these are your resources. And that is the end of my presentation, but if you have any questions, I'm happy to take them. Or, as I said before, you can always just give us a call at the General Counsel's office. Della will be back in the office next week if you'd like to talk to her, or I will be available after the meeting if you have any specific questions that you'd like to ask of me. Thank you.
Thanks.
Thank you.
Any questions? That was a great presentation.
Thank
I know
you.
we have some sitting chief appraisers and assessor collectors here on the board, so it's always good to be refreshed on the Public Information and Open Meetings Act. It's important that we follow those rules as public officials, but appreciate it. That was excellent. That was a good overview. Thanks very much.
Mr. Chairman, I have to say, I was coming to Delia. That is the best.
Yeah.
That is the best presentation on the most boring subject out there.
points.
Absolutely, it's incredible,
I know.
and it's necessary. Transparency is important, but it can get dry. And Elizabeth, you did a fantastic job.
Yeah.
You're going to get a lot of calls for this. You're going to be doing this.
And that's what I'm here for. So, yes, a boring subject area, but super important. We want to protect our agency and protect you guys, but also make sure that the public gets what they are entitled to get.
Outstanding.
We get lots of open record requests in our office.
Just a point, I think, I will second, you did a great presentation. I assume you're doing this for all of the boards,
We are.
and I
We
think
are.
it's important not only to do it once, but periodically to
Absolutely.
run through the cycle, because it is very important stuff.
I believe that we were doing it every 2 years for
That
the
should be-
boards, and every time the boards cycle in, there's some boards like your board that haven't met for a while, so we want to make sure that we always do that refresher. There are other boards that meet more often, but every 2 years, I have heard in the office is the standard for this training.
Good.
Okay, we're on to item D, approval of minutes for our meeting back in November 18th of 2013. At this point, I know we received those minutes prior to the meeting here, and I reviewed them, as I'm sure everybody has. Anybody want to make a motion to approve, or any corrections are needed?
I don't think I'll make a motion to approve.
I'll second.
All those in favor?
Aye.
Opposed? Motion passes. Good deal.
I'm sorry, who's second?
Lee Rosenberg, second.
Okay, we're to item E, is public comment. Do we have anybody here? Do we fill out a card? Is that still the
Absolutely.
procedure? I don't know. I don't see any cards that have been filled out. So, no public comments?
No, sir, we don't have any.
All right, great. On to staff reports. Briefing from agencies and on where we're at, where y'all are at, I guess.
Mr. Chairman, Brian Francis, Executive Director with TDLR, so I think that's one of the first changes we'll talk about. I took over back in September, and it's been a roller coaster ride, but it's been fantastic. Everything I paid for, I'm getting. The highs and the lows, all of it. And I'm really enjoying it. First thing I'd like to do, though, is to introduce one of my newer bosses, Commissioner Helen Collier. She is the commissioner who's a liaison to this particular advisory board, and I know Commissioner Collier may have a few words.
Hey, thanks guys for being on board and supporting this particular effort. It's very important, and I think important is sexy. I know that Brian mentioned about boring subject, but those are vital and very critical to the citizens of the state. So I appreciate everything that you're doing. Thanks Shane for your leadership, and look forward to working with you as we continue forward.
Thank you.
Mr. Chairman, I'd also like to introduce one of our newer members to our team. This is Nick Boenis. He is the Chief of Staff for our agency, and he's come on board. December 15th was his first day starting with us. I know Nick wants to say just a few things to folks.
Thank you, Mr. Chairman and members. It's a great honor to serve you. We've got a great bunch of folks, awesome staff. We've got a passion for what they do and to serve the state of Texas, and we're here to help you and serve you in any way possible. So thank you for the opportunity.
Right.
Mr. Chairman, I'd like to give a quick legislative update. During the session, we were tracking 4 bills that affected Chapter 1151. Of those bills, yes, please, thank you very much. One bill would have proposed to transfer the program to the Comptroller's office. Our dear friends at the Comptroller's office are right over there. They would have made perfect and incredible and impeccable host for the program. The bill was introduced, but it didn't move any further besides being referred to committee. There was also another bill introduced, House Bill 1738. That bill would have created a voluntary registration and certification program for the county assessor collectors, those folks who were exempt from the statute now. There was a desire that they still have the ability, if they chose, to be registered with us on a voluntary basis. That bill had a hearing, but it didn't go any further than that as well. I think you may recall that last session there was a bill introduced with a similar outcome and a similar purpose. I'd like to also point out that Senate Bill 929, while it does not impact the folks that are under TLR's regulation, Senate Bill 929 created a continuing education requirement, an authority really for the county assessor collectors to have CE, very similar to the continuing education they had when they were under TDLR. So I think that's really good to have both of the groups having that consistency as it relates to continuing education. Mr. Chairman, I don't know if you guys know, but TDLR gets a little busy these days, and this last legislative session was quite involved. Commissioner Collier, you're going to get the same report tomorrow, so you can either decide to listen intently today or tomorrow. It's your call.
Or sleep tomorrow.
You can sleep tomorrow if you want. I told Mr. Rosenberg and Shane that this was the most involved and intense legislative session that TDLR has ever undertaken. And that's not a small statement because we've had some really big sessions. But this go around, we attended more than 65 committee hearings. We were in 20 different committees for the different programs we regulate. One of the things that was important for me to go around this time was to build a significant amount of bench strength. And so we had about 15 of our employees that were geared up, ready to provide testimony. So it wasn't just Brian in the chair. We had Brad Bowman, our general counsel, Lee Parham, George Ferry, just a number of folks that were ready to do it. When I say the word ready, it involves a lot of preparation. When you're in that chair before a legislative committee, you're not just answering or available to answer the questions on that bill. You're talking about our whole agency, because this may be the only time that those members have an opportunity to talk to somebody from TDLR. So you have to know, so when's the last time you've done a fee reduction? How many employees do you have in X? And so it's a lot of preparation, the staff that they go through. We held some boot camps for testimony, and one of the particular boot camps, we had our folks doing their testimony, had members up there being very courteous and very professional representations of what they may experience at a hearing. And then I waltz in that door with the beach ball. And I'm just bouncing the ball and sit there at the table, because there are odd things that take place during the hearing. You have to keep your composure. You have to be focused. And I'm proud of the work and the professionalism that our staff has. We did record numbers in cost estimates. So at TDLR, for every bill that we may be involved in, the Legislative Budget Board will say, what do you think the cost is going to be to administering that brand new program, to changing or deregulating a program? What is the cost going to be? That information goes to the Legislative Budget Board. They then create what is called a fiscal note. The agency doesn't create a fiscal note, they do. And we did 219 of those this year. That's significantly higher than any we've ever done in previous sessions. We were tracking over 341 bills, moving through and having different impacts and touches with our agency. One of the things I'm super proud of, and Mr. Chairman and the members, you guys have been involved in this. It's the strategic planning initiatives that we go forward with. You know, every 2 years we will go around the state and we'll send out emails and we'll ask those questions of what do we do well, what can we do better? If you're king or queen for a day, what's the one change you would make in a rule, a process, or a statute that we administer? And then what do you think is going to happen over the next 5 years that's going to change the way that we have to regulate? And out of that strategic planning process, we develop strategic planning initiatives that we include in our strategic plan, and then we carry those forward to the legislature saying, here's what our folks have told us. Our licensees, our constituents, our employees, we think these are pretty good ideas. What do you think? And when we went into this session, out of a total of the 56 statutory recommendations that we included in there, 52 of them were sent on and passed, sent to the governor's office. It's a 93% pass rate. When you compare it to the legislative session as a whole, it's about 18% of all bills introduced get passed. And that's a statement of the effort that our staff had, but it's also a statement of the quality of the strategic initiatives that come through those discussions. We have great hair-pulling, you know, again, I started this job with the afro, so great hair-pulling discussions that leads to, I think, very actionable, reasonable opportunities. The first document that you have in front of you, this one here, that one kind of lays out those highlights by the numbers. It also gives you an idea of the initiatives that we move forward with. You'll notice that there are a number of deregulation initiatives. TDLR, coming through the process, we identified a number of programs that we said, hey, this doesn't require a statewide license. The room goes silent because people are not used to a state agency saying that. They're not used to an agency stepping forward and being bold and saying, this doesn't require us to do the work. There's not a consumer protection component that's tied to it. There's very little enforcement, and let's kind of loosen the reins on these. You can imagine that this session, that got a lot of attention, and there was a lot of enthusiasm about it, and a number of those bills passed. We're really proud of the deregulation efforts that have gone forward, and you'll see on the list, it's for the for-profit legal service contracts. It's for the dual license for towing. So we just made it smarter. If you're a towing operator, you don't have to have the towing in the VSF. You just have to have one license, and under your towing license, you can work in the VSF or you can tow vehicles. Just trying to be a little bit smarter than that. The booting, deregulation for the companies and the individuals, that will fall to the local municipalities. But the way the statute's written now, or will go forward, it will allow a person to boot unless a municipality says you can't. And that allows for that commerce to move forward without government stepping into it too quickly. It clarifies that threading is not required to hold a license here. It removes 2 licenses in the area of shampooing, a shampoo apprentice and a shampoo specialty license. It also deregs the temporary common worker employer program, and it also deregulates the vehicle protection product warrantor program. We didn't arrive at these easily, but we arrived at them smartly. And we're excited and we're proud that those were considered favorably. A couple of other initiatives that moved forward in our driver education program, which just came to us last session, there was an inequity in the parent-taught program. You're the parent and you want to teach your child how to drive. First of all, that's your dangerous call, but if you want to do that, the law allows for you to do that. But the statute was written in such a way that if a parent had an indiscretion in their 20s with a DWI, that they were banned for a lifetime from ever doing that. But the other category of teaching is if you're a driver instructor working in a commercial school, you only had to have, if you didn't have one within 3 years or 7 years, then you could teach. And so we wanted to bring that equity in there and saying that maybe this parent who had a moment of poor judgment 25 years ago, 30 years ago, shouldn't be held to that, as they want to move forward in teaching their child. We lowered or recommended that the bond be lowered from $25,000 to $10,000 because we saw that the experience rate in that area, that these are $75 courses, $100 courses, and we never had a scenario where there was more than $10,000 needed for that surety bond. So we lowered the cost of those folks that are operating in that area. Great call. We removed the risk-based inspection component. We have enough authority in our current inspection framework and regulatory framework that we didn't need to have that risk-based category. Removing the square footage limitation on specialty schools. Right now, if a person wanted to open up a specialty school that only taught manicuring, well, they had to meet the standards if they were running the full-blown school. So you had to have 2,000 square feet and you had to have 10 chairs, which you weren't going to use because you're only going to be teaching manicuring. And so we removed those arbitrary provisions that said you need to have this basic infrastructure in order to open a school. We've seen the benefits of lowering the square footage before. A couple of years ago, maybe 4 years ago, we went to the legislature and we said, lower the square footage requirements for the barber and the cosmetology schools. In the barbering area, we saw the schools go from 42 schools to 77 after that change went in place. And we expect that we'll see some more benefit in having smaller communities that may only have 500, 900 square foot of retail space available. Well, now they can put a school in that area, and that's going to be great for those students and that local community to be able to have that. So we're excited about that prospect going forward. One of our newer additions to our team is Eric Beverly. Wave at the people, Eric. He came on board, and he's just been gangbusters. He's sharp, he's intelligent, but I think he came on board for this one bill and this one bill only. And it's the bill that would, during the hearing, it was laid out this way. Members, this bill will provide liberty and freedom for your barista. And the member said, that sounds good to me. What it did is that it took espresso machines that are in coffee shops out of the definition of being a boiler. So, the espresso machines are becoming more high-powered, but we were able to do the analysis that there's never been an explosion, there's never been any catastrophic event associated with an espresso machine. So now those espresso machines are free. They are free from the tyranny of TDLR's regulations. And that man right there is happy. He's happy. I do not want to see your resignation letter. My job is done. It's not going down. You also may recall that there was a little bill called Senate Bill 202 that passed last session that moved 13 health-related programs to TDLR. We'll just let that kind of hang in the air. We brought 7 of the programs on last October, and it has been fantastic for us, but as well as for those licensees. We've answered more than 12,000 phone calls, 9,000 emails. They have kept in their pocket $98,000, meaning the fees they were paying before were $98,000 of what they're paying here at TDLR. They've experienced that benefit, so they have lower costs and higher service. And that's what we sell. That's what we do. That's what the staff provides every day. We will bring on the other 6 on November. Well, when we grabbed their statutes, we did a thorough analysis of it, and we found that there were some business impediment elements that were included in there. And this bill, House Bill 4007, it's one bill number, but it is probably one of the most comprehensive bills we've ever been involved in. The changes and the improvements that we're going to bring about are going to be phenomenal. I'll just throw out a few for you. With the hearing instrument fitters, there was a provision that said if you owned a hearing instrument fitter company, if you're a corporation, then the CEO, Mr. Walton, would have to be an individual hearing instrument fitter. If you had a partnership, then all the partners would have to be individual hearing instrument fitters and licensed. That provision is removed, and now it allows for a corporate structure to hire the right person who's licensed, but it's going to allow for greater competition across the state, and we just think that's a great thing for all of us involved. There's several others. We created what we think is a much-needed advisory board in the area of massage therapy. That program will be coming on in November. It's going to come with some great opportunities, some great challenges, but I know our staff is up for it. And then, Mr. Rosenberg, you're always curious about things that are new. Well, there are a few things that are being considered, and let me preface this by saying we are still in the veto period. So the governor's veto period runs all the way through Father's Day. So there could be some gifts that come out along that time period. So we're still monitoring that. But if you look at the document, that on page number 6, we have new and transfer programs. So the first program on the list is transportation network companies. You may know these as the groups that provide the rideshare service. Fasten, Ride Austin, Lyft, Uber, those are groups that fall in that category. They are now under TDLR's watch, effective on, was it May 29th, I believe? May 29th, the bill was passed, so we are slowly but surely, but quickly, but fastly building the infrastructure so we can have the regulatory framework for that program in place and up and running. House Bill 162 would provide for online courses for responsible pet owners. Basically, if a court finds, Shane, you guilty of animal cruelty, he was not, but in this hypothetical, Shane did it. If they find you guilty of this, they can say, you need to complete this course. That would be something we would offer. It's very, very similar to one of the new health programs that we'll be taking in November called offender education programs. So it's right there with the offender education providers. So we're going to be able to work that if that happens. House Bill 3078 and House Bill 1684 should be on there as well. But House Bill 3078 is podiatrist. So that is the medical podiatry board. Those folks will come under our regulation. The bill's been signed effective September 1. So we are spending the summer building and laying the tracks for the regulation of that program. We're excited about it. The program was administered by 4 employees for the state. And it's had 4 employees, and you can imagine how tough and how daunting that is to have a full-fledged state agency with just 4 employees. They are broad-shouldered, they are smart, they're hard-working, but it's a pace that you just can't keep up with. And so we're going to be able to provide some relief to them and their licensees and really give them some more services that they weren't able to get just because of the size, not because of effort and heart. Senate Bill 589 is for a behavior analyst. They provide services directly to young folks that are experiencing autism, and the magic they work in changing their lives is phenomenal. This will be a brand new program, and it'll start in June of next year, so we'll have an opportunity to build that, and we're looking forward to being involved in that. And then there's House Bill 1684, which provides for the regulation of industrial electricians. So we've got a lot of new stuff, but we have a lot of our existing programs. We're going to have a whole lot of work, so Delia and Tamla and our advisory board team, and as well as the rest of our employees, are going to be pretty busy, probably for the next, 22 months. Then we'll have a chance to go into the next session and see what comes out of that. I don't anticipate our strategic initiatives being as aggressive and as dense that we had this time around. I think we took care of a lot of not only the low-hanging fruit, but the things that really need to be addressed. But still, we'll go through the strategic planning process and see what comes out of that. And Mr. Chairman and members, that's all I have unless you have any questions.
Well,
I bored my boss. She ran out the room screaming.
Pretty impressive. Well, I know as property tax professionals, we always appreciate your common sense approach.
Thank you.
So I think that shows how much I think our legislators love your agency as well.
That's the first question in the interview that all these folks passed. Do you have common sense? And trust me, some people have said no.
so how many programs do you have now?
That's a great
Within-
question. Because of the up and down, on November 1, we'll be at 38 programs. And that's obviously the highest we've ever been. When Bill and I started, we were at 20 programs with about 149,000 licensees, and actually 145,000 licensees and 149 employees. We're going to be tipping the scale at about 760,000 licensees when that November date hits. But we're not doing it alone. We're doing it with smarts. We're doing it with technology. We're doing a lot of the thing you guys saw years ago. Remember when they created You Are Cooks? And you're like, I'm going to go to a steakhouse, pay you $50 so I can cook my own steak. And they're still in business. We do that. We provide a lot more self-service than allowing this very independent licensee group to take care of themselves with online renewals. So now they're putting in their data, they're putting their information. The accuracy is coming right off their fingertips. And that type of technology has helped tremendously. Our web presence has helped tremendously. We have probably 700,000 subscribers to our webpage, so we don't have to call everybody and tell them when we made a rule change. We're sending that information out to them, but we're also able to get it back. Our contact centers doing more than 500,000 calls a year, about 90,000 emails a year, and they're nailing it. They're absolutely nailing it.
How many employees do you have now?
We will have 471.2, a very, the .2 is one that's about my mother's height. But today we have 426 employees, and then as the session goes around, or as we move to the next biennium, we'll be able to hire up to 471.2.
And how much of this building do you occupy? Is this it?
No, we actually occupy the third and fourth floor here, and parts of the first. We now have a space with our education examination group that's on the other tower, really just diagonally from here. And then, of course, we're downtown at the EOT building, where out of the 11 floors, we have 10 of those.
Got a lot on your plate.
That's a lot on the plate, but, the staff knows my saying is that it's better to be at the table than on the plate. And here we are. Our success is allowing us to be very popular, and I'll take that any day of the week. Mr. Chairman, I'd like to do one more announcement, if I could, on a change.
Sure.
Supposed to have my jacket on, but now that my boss is not here, I can go jacketless. Oh, let's see what we got here. Many of you may not know, but this will be Mr. Rosenberg's last meeting with us. And there's no way that I would miss that moment or miss an opportunity to give him the praise that he's due. So we got a certificate for my friend. It says the Texas Department of Licensing and Regulation Certificate of Recognition and Grateful Appreciation to Lee Rosenberg for your steadfast dedication in serving the citizens of Texas for over 20 years. TDLR thanks you. For your willingness to serve and your uncompromising leadership as presiding officer of the Air Conditioning and Refrigeration Contractors Advisory Board, TLR thanks you. For your sage advice and spirit of teamwork as a member of the AC Advisory Board and the Property Tax Professionals Advisory Committee, TLR thanks you. For sharing your time, your expertise, wisdom with the TLR family, members of your professional community, and the citizens of Texas, TLR thanks you. For your patience in helping me grow as a leader with TLR and your professional friendship, I thank you. On this, the 15th day of June 2017, with great appreciation and gratitude, TLR salutes your service. Signed, Brian Francis, Executive Director and friend. Come on up here, Lee. Want to say a few things?
Well, the time flies when you're having fun. But it's been a great, great run. The value of this board, the other board that I served and chaired for many years, and what the TDLR has done is amazing. Also what's amazing is some of the employees that were here when this department was little bitty, they've now grown in their jobs, where maybe they had a department of 1, now they have a department of 30 or 40. And it's always great to see some of those people that have had the opportunities. Also, it's amazing that once Bill Coons came aboard, and I'm before him as a member of a program, things changed, the dynamics, everything has been wonderful. Also, I have to say that this little guy here has always been so inquisitive, and he's always learned more and more and more. His presentation just this morning was fabulous. And we're running a major operation here. The efficiency is incredible. When you think of 700 and some odd thousand licensees and collecting all that money, I think it's terrific. But it's been a great run, and I really appreciated everything that the staff has done, and wish you the best of luck going forward.
Outstanding.
And this actually will be placed in my office alongside a plaque that I have from then Governor George Bush, who got me started, I think, in all of this, along with Frank Denton. I thank you, my friend.
Mr. Chairman, so the first time that Lee and I met, he came as the adversary. He was going to set us straight. I was at the Real Estate Commission, and he was on the AC Advisory Board. And long story short, some of the residential construction or residential home warranty companies, they were taking advantage of the AC folks. They were making them do work below cost, and it was tough. Well, he thought we could do something about it. We couldn't, and I don't know if you guys have dealt with Lee Rosenberg and Mr. Rosenberg, two completely different cats. Mr. Rosenberg was in the meeting, and he was going to let us know what was going down, and during that discussion, we just clicked. There was something born out of that, and TDLR was no more on my landscape of life and my journey than going to the moon was. But we clicked, and as when Bill and I got over here, and I just recall that he was involved in that. We had a couple of advisory board meetings. The air conditioning program has been and is critical to TDLR's success. That program was the largest licensee program that we had when Bill and I came over, and they were the second largest in terms of revenue. Architectural barriers brought in the most revenue. And they were the voice that we had to work with in order to build some of the changes. One of the big changes, Lee, I don't know if you remember, was going from a 3-year license to a 1-year license.
Sure, I remember.
It was a big deal because we were going to lose revenue in that shake, but it was so difficult budgeting over a 3-year cycle. And you had a 2-year legislative cycle, and just we couldn't balance the money, and we had to convince them that this was the right thing to do, and it was going to allow us to be more consistent in the way that we handled business. And I appreciate working with you guys. Betsy, thank you for sharing them with us for so long. I appreciate it. Now you got them. Let me know how that works out, okay?
Well, let me just say this. It must be working because I started dating Betsy when she was 13. And we, in December, celebrated
Call the AG's office.
50 years of marriage.
Wow, congratulations.
Very sweet.
Appreciate it. We're going to take some pictures afterwards, so okay? We'll do that after the meeting.
Great. Well, the property tax professionals appreciate you, Mr. Rosenberg.
Thank you.
You've always been there for me, too, since the beginning. I appreciate that.
Could you help me with my protest?
That's so well. Fortunately, he's not in Dallas County, so that's. All right. I guess we're on to the compliance. The compliance division?
I am complete in my presentation. Compliance, I think we've got the able Mr. Russ Tolley.
Good morning, Board. I'm Russell Tolley, the Compliance Division Specialist for the Property Tax Professional Program. I just have 2 items for you today. The first is I'd like to recognize Roger Thormalin, who's recently retired. He is here today. He did a fantastic job with the PTP program for us, organizing it and setting it straight, and we really miss him. But looks like he's enjoying his retirement. He's nice and tan, so I'm sure he's enjoying his grandkids and doing all those things like working in the garden. The other thing I wanted to bring up, well, let me introduce Lisa McDonald back there. She and I are now the primary program specialists for the PTP program, so if you have any questions or comments or any work you want us to do, please go ahead and contact us directly. We're happy to work with you. The second item I have today was a brief overview of the Methods and Assistance Program, that work we do as a result of referrals from the Comptroller's Office. Most of you here today probably are already familiar with the Methods and Assistance Program. Briefly, those programs run on an every other year cycle for the county CADs. They have 1 year to resolve any outstanding comments with the Comptroller's Office. If those unresolved comments need further review, it's then referred to us for additional work with the counties. We're currently working with 4 counties this year that have been referred to us, and the trend line for unresolved comments from the counties is really markedly lower. Normally we have roughly 8 or more counties referred to us with multiple, sometimes 10, 20, 30 different recommendations that have not been fulfilled. This year we had 4 counties referred to us, and most of them have 1, 2, or 3 comments. So PTAD and Comptroller's Office has done great work with their MAPS programs. We're happy to continue working with them, and we look forward to continue doing that. Any questions?
Just a comment, I really appreciate Mr. Thormalin over the years. You've been always there, had a question, always got me back on track, and I really appreciate all your past support. So, and then I know with the MAP, it's been a good thing for our industry, and we appreciate what Property Tax Assistance Division does with regard to that as well. But I think it's really improved the industry as a whole, and it continues, to be, we continue to see you all every year in our offices. It's a good thing.
Mr. Chairman, I'd just like to add, I think Russ has done a fantastic job with the MAPS program. It came to us, it wasn't formed, and he has built it. He's built every inch of that program, and he owns it. He does a great job in doing the analysis, and more so, I love his touch, his approach in dealing with these smaller units, and they're struggling. And he brings a compassion that gives them a path success and allows them a way to not feel bad about falling a little short and feel like they can pull themselves up. And he's done a great job. And Russ, I do appreciate how you do that.
Thank you, Brian.
Absolutely.
Thanks, Russell. Thank you. Well, I think it says a lot. There's only 4 out of 253 appraisal districts that have risen to the compliance division here. So that's a good thing, I think, for the industry, too. It speaks a lot about how well we do in the industry. So I guess we're on to the Education Examination Division. All right.
Good morning, Mr. Chair and Advisory Board members. My name is Rebecca Adamus, and I'm with TDLR's Education Examination Division. Just to kind of echo what Mr. Rosenberg said this morning, in this agency, we grow, and we're allowed to grow, and given the opportunities to grow. So in your report, you'll see that we've gone through some changes as a division. Mr. Dudley has retired, and Mr. Pizarro is now our division director. So there's kind of proof there. Myself, I started in customer service 9 years ago, and I have now moved on to the Education and Examination Division. So this is definitely where to be as far as wanting to grow and move forward and progress in our careers. In 2015, kind of what was mentioned before, the driver safety and education team came over to TDLR, and with that, it brought, again, more growth to our division. So we have our own driver education and safety section. We have an inspection section, and of course, we have the education and school services, which most of you probably interact with a lot more than the other groups. We've grown. Before education examination was maybe a division of 7 people. We're now up to 18 and growing. We take care of all of the inspections for the education aspects for driver safety and training, cosmetology and barbering. We're going to be taking on massage. And it's just something that we take pride in the fact that, we are able, with our wonderful staff, to make sure that we maintain those inspections. My role in the division is education liaison. I go out and visit the schools. Any school that wants me to come visit, I will come spend some time with them, make sure that they're in compliance so that when they are visited by our inspectors, they have a great experience. They've got everything that they need to stay in compliance and avoid any type of findings. And some other pages that we have in our report will show you the statistics that you'll be seeing as far as examination pass rates and continuing education courses that are submitted. And that's about all I have for you.
Appreciate the stats. Just, on our examination statistics for the industry out there, we're right, in 15 we had a 59% pass rate, almost 60% in 2016, and we're currently for fiscal 2017, we're at right at 57.6%. So, that's just for the folks to know out there. I know too, is PSI still the
Yes.
the agency
Yes,
that
sir, they
works?
are. Mhm.
So I know too, just for the folks out there that may be watching, that basically we do have a examination review committee that gets together every 2 years with the RPA and the RTA, RTC exams, and we're looking at those questions that are too easy and too difficult, and ensuring that our exam meets the minimal level of competence for those that need to be in the industry. And I think it's meeting those needs right now. So I'm real happy with Mr. Pizzaro and with your group and what y'all are doing. So it's great.
Anything else?
It's great.
Good job,
Thank you.
Appreciate it.
Thank you.
All right, Enforcement Division.
Good morning, Chairman and members of the Advisory Board. My name is Kim Davenport, and I'm here as a prosecutor with the Enforcement Division to present the staff report and talk to you about the 4 cases that have agreed orders or default orders that have been entered since the last time you met in November of 2013. There were 3 default orders and 1 agreed order. The first 2 default orders that are in your case summaries involve the same individual who is an appraiser, and that is Danny Fling. It was a matter where he was engaged actively in appraisals at a time when his license was expired. For about 5 or 6 months, he renewed his license. The department filed a notice of alleged violation. He didn't respond, and a $300 administrative penalty was ordered as part of a default order. The second default order was as a result of him not paying that order. The department filed to revoke his license, and it was revoked. His license is still inactive, and he never paid the administrative penalty. The third order and case that is in your summary is regarding an agreed order that came as a result of an individual who was taking an appraiser exam and used unauthorized study materials. She was stopped in the exam. She was assessed an administrative penalty of $1,500, which she entered an agreement to pay with the department. She has paid that $1,500. Her license is currently not active. The final order is a little more interesting case than any. This was a default order and involved the chief appraiser for Duval County Appraisal District, who was found to be writing checks to himself and other employees of the district office. These were unauthorized bonus checks. to the amount of about $300,000.
I'm sorry, could you repeat that again?
$300,000.
We're in the long line of work, okay.
Okay. Yeah, this resulted in a default order, an administrative violation for abuse of power for engaging in conduct that was misleading and/or fraudulent. Just for the board's information, he was charged criminally by the county. He is now deceased. I contacted their office this morning just to see what the outcome of the criminal charges were, and there are still actually criminal charges pending against other individuals, but he passed away last October, so no administrative penalty was ever paid for that case. I also believe you have some statistics for the department and for this program specifically from fiscal year 2015, 2016, and 2017, as well as some program statistics from the inception of the program. As you can see, I think you have this information, but since the program has started, we have had 336 cases opened. 259 of those have been closed informally. 5 of those closed with the statute change regarding the county assessors no longer needing to be registered. There's been 15 disciplinary actions and 7 warning letters. Specifically, I think right now we have actually 31 cases open as I checked this morning. You go to 2017 for the fiscal year, and these statistics are as of April of this year, so there's a few months left in the year. There was 26 cases opened, 34 cases resolved. There hasn't been any agreed orders or administrative penalties collected or assessed, but if you look for TDLR as a whole, had over 8,000 cases opened and close to 8,000 resolved, $3.7 million in penalties assessed, and about half of that, or a little less than half of that, collected. And then we have the previous 2 years as well. And in 2016, I think at least the case with the agreed order, as well as the case with Mr. Garza in terms of the Chief County appraisal, those penalties were assessed and collected. 51 cases opened in this particular program, 33 resolved. I'm open for any questions you may have about these.
Well, our goal is not to have any cases.
That would be great.
So you can focus on the other industries.
That would be our goal as well. Thanks so
All
much.
right, thanks.
Thank you.
Thank you.
Kim, that was a fantastic report. Good job.
We appreciate all the statistics, too. Okay, licensing.
Good morning, Chairman Dougherty, Mr. Rosenberg, and other advisory board members. Good to see you guys again. It's been a long time. The PTP program has been running amazingly well in the licensing division. We have a lot of talented people in the licensing division that keeps this program running well. There haven't been a lot of changes. When you look at the statistics, they have fluctuated over the last 4 years. The most fluctuation being the total population for the appraisers. The collectors, assessor collectors, the numbers have been pretty consistent. We've had a couple of other changes. The fees were lowered. February 1st, 2014, the fees went from $55 to $45. The only other significant change I would say that has happened since we last met is that as of January 1st, 2015, all chief appraisers have to complete a 4-hour chief appraisers ethics continuing education course to renew their chief appraisal license. And we're all government officials. You guys are government officials. We're government officials. And I think as a whole, we're all working very well together. Do you have any questions for me?
How many hours did you say that ethics course was?
4.
4? And that took effect when?
January 1st, 2015.
We appreciate it. I know we're just a small piece of that 760,000 licensees, so, but that's, we really.
But an important piece.
I know, and I really appreciate it. I know with our agency, you all do a great job of us renewing and all those things with our
Thank you.
licenses, and it's really worked out well. We
Yes.
appreciate everything y'all done. for us.
Thank you, guys.
Appreciate your support.
Great job, Joyce.
Great reports. We appreciate you getting up to speed last year or two. Well, we're down to G, recommendations for agenda items for our next meeting. I don't know if anybody has any thoughts. I know we do have a special session pending. Fortunately, you know, we got lucky as property tax professionals. There wasn't as much that came out that was, you know, there was a lot of bills introduced, but there wasn't a lot that came out that was substantive in nature to changing, you know, our landscape, which is always a good thing, I think. But I know we do have a special session coming up, and there may be a need. If something happens, we may have to get back together. I don't.
That's exactly what I was thinking too, Mr. Chairman. Obviously, there are a few items on the call
Right.
that could address property tax.
Right.
And it's going to have some implications to your group, not your license per se, but basically how you operate your shops. And I think if there's anything that comes out of that, maybe having a meeting sometime in November would be appropriate.
I think that's a good idea. I know y'all have a lot going on, so we don't want to have meetings just to have meetings. I think that's
We
what's
appreciate that
important, too.
more than you know.
And, you know, too, if the rules are working, they're working well, there's no reason to change the rules either. I mean, I know that's important. I think, you know, it took, early on, we had a lot of things going on. We got them up to speed. I think we got a lot of good checks and balances in place within our rules. They're working well. Haven't really had, I've had some feedback from some registrants, you know, two things I'll just bring up real quick.
Please.
Well, one was other programs, whether you're a state licensed appraiser or you're a consultant wanting continuing education hours. And what I try to get back to those folks is anybody can submit a continuing education program through Property Tax Assistance Division.
Correct.
So people that are in those industries, they should, that cross over into our industry, they should promote the people who are putting on those continuing educations to ask Property Tax Assistance Division to possibly look at it and see if it meets those criteria. And I think that's one that came up. And another thing was with regard to licensing, I know we have some people that wear both a RPA hat and an RTA, RTC hat. And I know I fielded a question with regard to, I think some people that got their RTA after their RPA, that they have two different renewal dates. You know, the question was, can we ever allow them to have one renewal date for both designations? But, you know, as I told them, I know everybody needs to act and act reasonably on their own and make sure that they're fulfilling those CE requirements. But that is something that's come up. I think there's a small few in that. I think a lot of the people that are the RTA, RTC, and RPA way back when they did get one renewal date for both licenses. But I don't know what thoughts are, what TDL are with regard to that. But outside of those really issues, hasn't been a lot that registrants have come to me about of concern within our rules and things, which I think says a lot.
Okay.
You know.
Mr. Chairman, we can take a look at that. There are some provisions in some of the statutes that allow for us to stagger and modify
Right.
the renewal periods and license periods. One of our programs, Service Contract Providers, we've been able to accelerate a renewal for that company so we could align it with its annual report. And so it meant that they had a shorter license, like in 1 year, so maybe it was a 9-month license, but then that lined it up with its annual report, and then from there on out, they were going there. And so we may be able to do something there, because it's a small universe.
Right.
We could identify everybody in that group, and it may be 10, 20, or 30 people. So we'll take a look at that.
Okay. You know, and outside of that, I mean, we've had, you know, I work with Property Tax Assistance Division. I'm on the board of the Property Tax Education Coalition that develops the core curriculum. It's approved by PTAD, and again, we have a lot of good communication between Property Tax Education Coalition, Property Tax Assistance Division, Texas Association of Appraisal Districts, Texas Association of Assessing Officers. So I think we're all pretty comfortable where we're at this point with regard to our rules. And those are the issues that have been brought to my attention over the last 2 years that I don't know if y'all have any questions or anything you can think of I think things are working well. So if we don't have any special sessions, I'm not really sure, coming out of special session, we're gonna need a meeting anytime in the near future.
And we'll check back with the board
Yeah.
just to see what happens after
Exactly.
July 18th.
So I guess, and that gets us to H. I mean, basically, at this point, there's no need to talk about a future date unless we hear back, you know.
That'll be great.
Okay, I know I don't envy your task coming up. I remember the last session, all the things that were going on too, so,
You heard all the reports. We got great people there.
yeah.
And this is the tip of the iceberg. They have folks that work with them that are just as talented and provide the support, so we got a great machine.
I've got a comment. I have, over the years, served on a number of boards, and of course, a couple of boards here at TDLR. But I have to say, Shane has done an outstanding job as being the presiding officer of this board. He communicates well, he's prepared, he calls me from time to time, not walking around.
Roving quorums.
But Shane, you've done a super job. And it actually, it takes work to be the presiding officer, it really does, being prepared.
Well, I appreciate TLR's support and everybody in the industry's support and the citizens that are willing to sit on the board. I think we're in a good place. But there are always room for improvement, as you know, so. Well, with that, I think we can adjourn unless anybody does anybody have, Sydney, you have anything or two?
No,
Mike?
nothing else really.
Okay.
Mr. Rosenberg should make our motion to adjourn.
Yeah.
Yes, being this is your last meeting.
Actually, let me think about that.
If you don't, I will.
All right, I move that we be adjourned.
Second.
Done. All right, thanks. Mr. Rosenberg.